Hello friends, welcome. Friends, this is the headline of the day, which is the shocker. Everybody must be confused totally because this matter is of utmost importance because Vodafone Idea has moved to Supreme Court to squash an additional demand by DoT of 9,450 crores on fresh AGR demand. This is on top of the existing AGR demand or the liability which stands at 82,000 crores as of FY26. If you see this, you might be already recognizing this Excel sheet which I use in all my videos. So here I have quantified it at roughly around 82,000 crores, which is the current liability. So whatever is the demand which DoT has raised is on top of that. Now friends, the question comes that from where this demand has come. Question number one. The second question is it a surprise or were we aware of it? Right? Because that is a very important question, that whether we were aware of this 9,450 crore or it came as a surprise. And second is that whether it is a violation of Supreme Court judgment or not. Whether the Supreme Court allowed reassessment on part of DoT. And the fourth question is that what caveats were put by DoT when they filed an affidavit before the Supreme Court which quantified the preliminary assessment. If you recall the DoT's affidavit here, I'm going to show you. This had the preliminary assessment of all the dues. What caveats were there which DoT had put out here, which Supreme Court in their judgment captured verbatim, and then gave a judgment which said that there shall not be any reassessment. We will answer all these four questions. First question is whether this amount which you saw was a surprise or not. Friends, before I answer that question whether it was a surprise or not, let me take you through my video which I posted 1 month ago, which was Airtel's AGR provision spike explained. Now, many of you cannot understand what did I do in this video and what is this provision all about. You are only aware of dues. Now, friends, let me explain to you. See, Airtel came out with their annual report just recently, which I went word by word. And when I went through the annual report, I found this page and this table. This page was page number 450. In that, I found that the provision for the AGR matter was increased by 7,516 crores by Airtel and contingency was reduced by roughly around 4,000 crores. Now, friends, what is the difference between provision and contingency, and what is this amount which is listed here on AGR matter, which is a substantial amount of 35,000 crores on top of the existing Airtel's liability towards DoT on AGR. What is this all about? For that, friends, we have to understand the difference between provisions and contingency. Now, what is provision? Obligation is probable, measurable, booked in the balance sheet. Means it is in the part of the balance sheet, means it is almost like a debt. Contingency liability means obligation is possible but not probable, disclosed only in notes. So Airtel had contingency and provision, and they have decreased contingency in FY25 and increased that in provision, which I captured in this Excel sheet. Let me tell you. This is the Airtel's overall AGR debt, which stands at 38,604. And if you go to Airtel's contingency, which is not part of the balance sheet books, it is not demand, it is probable, you'll see that this on AGR demand, on Airtel contingency liability on DoT demands, which is the major portion was AGR, kept on increasing and suddenly dropped by 4,200 crores in FY25. And what increased was this amount, this AGR matter provision, which increased by 7,516 crores and now stands at 35,211 crores. Now, Airtel doesn't have to pay this full 35,211 crores because substantial portion of this provision is being indemnified by Tata and Telenor. What is not indemnified? 12,832 crores. And that, if you add to Airtel's debt, now it stands to 51,437 crores. So this came to my notice. And in that video, I did mention one more thing, that look, we have understood that Airtel has got an additional AGR liability to the government of 12,000 crores plus, and that is on top of the Supreme Court judgment. So what is going to be the impact for Vodafone and Idea? I raised in that video. I did not quantify it. I just posed the question because I am waiting for the annual report of Vodafone Idea for FY25. Now, friends, after having seen the annual report and the past annual report, I have listed down all the details from the Vodafone's annual report starting from FY21, 22, 23, 24 and 25, where DoT's demand and other licensing dispute has been captured as contingency, and explanation is given in note 3, which increased to in FY25 to 10,580 crores, of which AGR amount was roughly around 9,000 crores. Now, this amount not exactly, but approximately matches with this amount, which we are talking about here of 9,450 crores. So, if we say that it was a surprise, it was not a surprise. Why? Because this was already part of the contingency. Now, in order to show you that Airtel's annual report included this amount, I have to show you the annual report starting from FY23. So if you look at FY23 annual report and if you see notes 3, you will see that, I'll just read out. On June 29, 2022, company conveyed this acceptance of deferment of AGR related dues. Means they wrote a letter saying that we accept the deferment of AGR due, which is part of the DoT's package or the Government of India's package, till FY19. See this. The above mentioned letter has a summary, means that letter which we put an acceptance of additional AGR dues amounting to rupees how much? 8,837 crores, which is 9,000 crore approximately, including amounts for the period of FY 16-17, not forming part of the affidavit submitted by DoT in the Supreme Court. What does it mean? It means that this annexure, which laid out a demand of 58,234 crores, did not include that amount of 9,000 crores, which they have accepted in their letter when they had given to the DoT as for acceptance of the AGR due deferment as a part of the moratorium, right? So this was not only part of the FY23 annual report, but also part of the FY24 annual report. You see note 3. Same, you can read, pause the video and read. Here, right? And it says that DoT has mentioned that these are subject to further. So why did DoT was able to levy additional AGR due? Because of the following reason. Because if you go to DoT's affidavit, which they submitted on 16th March 2020, just before the 2020 Supreme Court judgment, here you will notice that they have made a caveat. Total demands have been calculated generally up to FY 16-17. On these, outstanding amount, interest, penalty and penalties calculated up to October 19, right? All dues are subject to further revision due to department assessment, CAG audit, special audits, court cases, etc. So they have a caveat here. And this caveat in Supreme Court in their judgment, if you see the judgment, if I go to the preliminary assessment part of the judgment, which is in the top part of the judgment here, I'll note, you see this is preliminary assessment. You see the amount recoverable from major TSP preliminary assessment, part of the Supreme Court 2020 September judgment. Here you will see the same caveat is put out here. All dues are subject to further revision due to department assessment, CAG audit, special audit, court cases, etc. Verbatim. But if you go down below in the Supreme Court judgment, here you will go down below, which is the last page of the Supreme Court judgment. You will see that the Supreme Court judgment clearly says that for the demand raised by Department of Telecommunication in respect of AGR dues based on the judgment of the court, there shall not be any dispute raised by the telecom operators and there shall not be any reassessment. Now, this is a legal statement, friends. because it says that there shall not be any dispute raised by the telecom operators, which the telecom operators tried to clarify before the Supreme Court. They also filed an appeal in the Supreme Court in 2021 to rectify this judgment, but Supreme Court did not agree. And they also said that there shall not be any reassessment. Now, this is a legal statement. Reassessment means what? Reassessment just because the TSPs are asking for reassessment, or the DoT because of their caveat will do reassessment, can do reassessment. This has not been explained by the Supreme Court in their judgment, which is September 2020. And that is why this amount of 9,000 crores, which you are seeing here, which DoT has raised on the additional amount, which was already finalized by the Supreme Court in the 2020 judgment of 9th September judgment, 1st September 2020 judgment, is now being presented before the court. It's been petitioned by the Vodafone Idea in the Supreme Court for squashing, because now Vodafone Idea is saying that this amount that DoT has raised is illegal because Supreme Court has finalized the AGR AGR case and said that there shall not be reassessment, and Vodafone Idea asked for reassessment and it was disallowed by the Supreme Court. That the net is the overall summary of this case. Now, why additional demand has been raised? Because the ground, there are a lot of people on ground and DoT, they keep doing reassessment. So they have been doing reassessment on reassessment, and they've been sending these to DoT on an ongoing basis. And since DoT already had the caveat in their filing before the Supreme Court, which is this is the Supreme Court Annexure A5, which clearly said that this is preliminary assessment, on the basis of which Supreme Court decided on their September 2020 judgment, and the caveat was clearly said that all dues are subject to further revision due to department assessment, CAG audit, special audit, etc. That is the reason why DoT feels that it is empowered to issue additional demand, because this line has been verbatimly included in the Supreme Court judgment. You do understand now what the problem is? And Vodafone Idea was aware of this because they have been including this amount, 9,000 crores, already part of Note 3, which is the contingency liability. And Airtel was also including it, part of both provision and a contingency liability. Now it appears that Airtel got an additional demand of 12,000 crores, right? Which I produced here in these Excel sheets. If you look at this, Airtel AGR, this is the spectrum. Leave aside this. AGR debt stands at 38,604 crores, FY 31st March 2025. On top of it, there is 12,832 crores, right? So this amount stands at 51,437 crores. Now for Vodafone Idea, what happens? We already know there is an amount of 82,000 crores. Now if you add 9,000 crores on top of it, it goes to 91,000 crores plus 92,000 crores. So this becomes 92,000 crores. And that is the reason why, friends, Vodafone Idea has now filed an application to the Supreme Court asking for reclarification of this word, this phrase, there shall not be any reassessment. And if there is no reassessment and corrections of errors which were allowed, right, by the Supreme Court, how can the Supreme Court permit DoT to correct errors? That is a question, right? The caveat which DoT had clearly put out here, saying that all dues are subject to further revision by Department of Assessment CAG. How can that be allowed, and why the operators are not allowed to submit their views on DoT's assessment? So it's a complete violation of Article 21, right? It's actually a very unfair situation, no doubt about it, right? The right to equality, right? If DoT keeps on doing reassessment, which the court clearly says that will be no reassessment, operators are not allowed to do, submit their queries. They are double counting, everything DoT can do, whatever they want to do, right? The Supreme Court judgment can be modified, can be twisted, everything can be done, but Vodafone Idea or the operators will not be allowed to do reassessment. So what kind of judgment is this? This is the point, friends. Now, whether Vodafone Idea is going to get a relief from the Supreme Court or not, I don't know. I have no clue because it is up to the Supreme Court. But I can tell you this is the most unfair thing which I have come across in my career. There have been many, many unfair situations. The AGR case is the most, you can say, most unfair judgment which I can think of in my overall telecom career, which has been driven by an Indian Supreme Court, which is the supreme authority of justice in India. What kind of judgment is this? There cannot be a reassessment, and DoT is allowed to put a caveat here, right? And you don't say anything about this caveat. How can you allow that, right? So I think that is the reason why Vodafone Idea is well within its right to ask for a reassessment of the full AGR dues of 92,000 crores, which include the 9,000 crores for 450 crores, because this amount stands at 82,000 crores in FY26. Now, if you add 9,400 crores, it will go to 92,000 crores. So there needs to be a complete reassessment of the full dues, because there has to be some kind of double counting, etc. When if you are not allowing the operators to submit their grievances on the calculation mistake, DoT can do whatever calculation they want to do, right? Because DoT there is absolutely no way anybody can oversee their calculations. This is the most unfair situation any company can face anywhere in the world. This is unheard of. This is absolutely, fallacy of justice. So anyway, friends, I'm going to stop here. I think probably you understand why this demand was raised and whether this was a surprise or not. This was part of the contingency for Vodafone Idea, including Airtel. Airtel has put some part of it in provision, and looks like that Vodafone Idea has done the right thing by submitting a case in the Supreme Court for complete reassessment. Not only this amount, but the full reassessment, because it is a violation of the Supreme Court judgment. DoT is being allowed one-sidedly to keep on revising the AGR dues. Thank you, friends, for your time. I hope that you like this video. And thanks for listening till the end. I'll come back with a new video and a new topic next time. Thank you very much, friends, for listening.